So they found fingerprints and boot prints and DNA of some other guy. There's foreign DNA, foreign fingerprints, foreign boot prints. The bloody footprints tracked inside Gail's home do not match Marcellus Williams. The hairs found near her body do not belong to Marcellus Williams, and the kitchen knife does not bear his fingerprints. So they got evidence of another guy's footprints and fingerprints and DNA. Holy shit! Holy shit! How is that not exculpatory? I also wonder if Marcellus Williams was actually indicted by a grand jury first. Fifth Amendment, Clause 1 says that before you can put a felony on somebody, you got to get a grand jury indictment first. A lot of these bastards don't do that. A bunch of times you'll just have a badge, kidnap a body, and then everybody, all the bastards, just rubber stamp, rubber stamp, rubber stamp. After additional DNA evidence on the murder weapon came back this August, matching that of the assistant prosecuting attorney and one of the investigators. Well, shit, maybe they did it. Maybe the assistant prosecutor or the investigator did it. They had DNA evidence on the knife, but not Marcellus Williams. He didn't have any DNA evidence on the knife. So maybe the real culprit is the investigator or the assistant prosecutor, both of whom ultimately admitted in affidavits that they handled the knife without gloves ahead of Williams' 2001 trial. So apparently there's blood evidence, and then there's touch evidence, skin cells. County prosecutors and defense counsel entered an agreement August 21st designed to take Williams off of death row, but later that day Attorney General Andrew Bailey blocked the agreement. It is in the interest of every Missourian that the rule of law is fought for and upheld every time without fail, Bailey said in a statement following his filing, adding all the evidence the jury relied on to convict the defendant remains intact. The victim's personal items were found in Williams' car after the murder. A witness testified that Williams had sold the victim's laptop to him. Williams confessed to his girlfriend and an inmate in the St. Louis City Jail, and Williams' girlfriend saw him dispose of the bloody clothes worn during the murder. All the evidence in question was available at trial. The two witnesses that they relied on, an inmate, so a jailhouse snitch, well, they got the $5,000 reward money. The girlfriend, both of these guys are dead, by the way, he said that he got the laptop from her. County prosecutors said in a motion to vacate in January that the witness testimony was undermined and that the duo were known unreliable witnesses who would lie to help themselves. County prosecutors further alleged that the only physical evidence corroborating the girlfriend's testimony was the laptop, which at the time of pawning Williams and his girlfriend had given him to sell. Now, that is good evidence. They found some of the items in his trunk. He used his grandpa's car, so it could be his grandpa's Buick. But apparently, they go to his trunk, they lift open the trunk, they pull out some of the personal items of Gail, Felicia Gail. Now, he's going to say that the girlfriend had given it to him to sell. So he got it from the girlfriend. And then who's the girlfriend? What's her name? At trial, a jury of 11 white people and one black person convicted. And then there's the husband. 11 white people and one black person. Is that a jury of your peers? 11 Caucasians, one black guy? And then 9 peremptory strikes. 9! You get 9 strikes, and then they use 6 of their strikes to keep 5 black jurors off the case. That is racist as shit. He wasn't tried by a jury of his peers. He has the presumption of innocence, and you got to prove this case beyond a reasonable doubt. And so, while that evidence about him having some of the stuff of Felicia Gale's in his trunk, or at least the car that he was using, what about the granddad? What about the girlfriend? What about the husband? That's pretty damning evidence. But so is the DNA. The lack of DNA. The DNA says that there's somebody else. They found a hair sample. They found blood. There was a boot print. There was fingerprints. And then guess what? They're going to destroy the fingerprints. They destroyed the fingerprints, and they're trying to say that this is just standard operating procedure. The fingerprints wasn't good enough. It wasn't good enough. There was a partial print. It didn't come to anything conclusive. So he destroyed them. Well, that could be exculpatory too. Alec Baldwin, he got to walk because of some ex-Arizona cop put a bag of bullets onto the desk of the prosecutor and she didn't think it had anything to do with the case. But the judge was like, wait a second, that could be exculpatory evidence. Case dismissed. Get out of here, you murdering Alec Baldwin son of a bitch, you. Explaining those decisions in court last month, the prosecutor at the time, Keith Larner, testified per the filing that he struck one such juror because he thought that the man resembled Williams, who's also black, saying that they look like brothers, in part because they were both young black men with glasses, and that the potential juror had the same piercing eyes as Williams. The same piercing eyes. So, Your Honor, that guy looks like a peer. We don't want a peer in the jury pool. Okay, held up. Missouri Supreme Court will hear the case on Monday, just 24 hours before Williams' scheduled execution on September 24th at 6 p.m. Central Time. I watched the actual Supreme Court thing, and the only thing we're talking about is due process. They're not even trying to talk about the innocence. They try to get it out of the damn attorney, but they're only arguing about process. Whether or not that one black juror that Keith Larner had thrown out, because he's testifying to two different things here. He's saying that he struck one guy out because he was black or that he looked like the same guy. But then the other guy said, did you ever throw any out? And he says, absolutely not. So the one lawyer said that Keith Larner said that he didn't do that. And then the other lawyer said that he did do it. And the question wasn't, did you do it, one time? It was there systemic racism? The Supreme Court heard the case Monday, today. Tomorrow is when Marcellus Williams is scheduled to be executed at 6 p.m. Central Time. Both witnesses have died. I'm not even for sure if Daniel Picus, that's the husband's name. Osaro, Laurel, I'm not for sure. The girlfriend. That to me, you have a presumption of innocence and you have to prove in a criminal trial that the person is guilty, beyond any reasonable doubt. I once heard that standard is an impossible standard to reach. Beyond reasonable doubt. Unless you saw it for a fact or you got evidence of videotape that says that it happened and you see the person with the gun pull the trigger, the other person gets shot, goes down. You won't be able to videotape that. Maybe surveillance. Maybe you would get some kind of surveillance. Because videotape is the eyes of God. You cannot dispute videotape. All these other, circumstantial corroborating evidence. Does him having stuff in the trunk of the Buick, was the Buick his? Was it the granddad? Was it the girlfriend? Did we even ask about the damn Daniel Picus? And then the partial fingerprints would be exonerating too. And the partial fingerprints, we got better technology, so had they not, why would you destroy it? Why would you destroy evidence at all? It's like, what is this? Oh, it's just fingerprints. Well, get rid of them. Get rid of them. Why wouldn't you put that in some sort of database or put it in the damn file? Nah, you better make sure you light that shit on fire. Taking the life of Marcellus Williams would be an unequivocal statement that when a white woman is killed, a black man must die. Any black man will do. NAACP President Derek Johnson wrote in an open letter to Parsons. Yeah, this Andrew Bailey sounds like a piece of shit. He doesn't know what's right or wrong. He doesn't give a shit about right or wrong. They just want finality, right? Look, the cop kidnapped you. The cop kidnapped you, then we fucking fuck you with an arraignment, then we fucking fuck you with a dispositional and the preliminary. We won't even get you a grand jury indictment. Then we'll fuck you with the evidence. We'll fuck you with the witnesses. We'll give you a public pretender. We know you can't afford a damn lawyer. We'll fuck you and fuck you and fuck you some more. Then you get into jail. Maybe you'll be able to file the petition, but that's 2 days late, and then you didn't use the right font. It's going to get thrown out on a technicality. It's actually incredible that this man has not only like defense attorneys, but he's got prosecutors and judges who's sitting there saying that he's okay. They had a board of inquiry. Here's what I think should happen. They should have an evidentiary hearing. Look at the damn evidence. Do you have enough evidence to convict? Do you have enough evidence to even bring up a charge? Do you even have enough evidence that there was probable cause that he's the one that did it? Do you even have evidence of it? He already took a plea deal. How come he took a plea deal for life and now we're going back on the plea deal? We're breaking a fucking another agreement? I saw an interview with his son. His son was like, he's going to be there at the execution, you know, watching, and he's prepared for it, which is like the anguish that capital punishment, you know, justice is eye for an eye. But because the DNA, I just trust DNA evidence so much. Not only do you have blood, but you also got fingerprints, and you got boot prints, and you got hair samples and skin samples. The DNA says that it's somebody else. The boot prints, the fingerprints says it's somebody else. Them destroying evidence says it's somebody else. Some stuff of hers being in his trunk, okay, that could be something, but that doesn't convince me beyond a reasonable doubt. If anything, the DNA, the blood DNA of somebody else, that convinces me beyond a reasonable doubt that he didn't do it. And so when I hear that he has stuff in the trunk, it's like, okay, that sounds really bad. But what are some possible explanations? Granddad bought some shit. They're pawning shit. They're both robbing and stealing. It's stolen goods. The guy that testifies against him, the guy that bought the shit. How much shit do pawn people always buy stolen shit, then they sell it to somebody else? And now you are the recipient of stolen property. And then if it was true that he had confessed to the girlfriend, Laura, I want to say Osero, why didn't she come forward? Why didn't she testify? Why didn't she report the crime? Because there were two peas in a pod? Because they were, what do they say? They're partners in crime. They're partners in crime. No, Your Honor, it wasn't me. It was him. No, Your Honor, it wasn't me. It was her. So who was it? It could have been Laura. They, said it was him. She's out. I'm not sure about the jailhouse snitch, but Laura Osero's out. Wants to get the $5,000, takes the stuff that she had robbed or robbed with him, puts it in his trunk, calls it in, and then they come in and they find it. And then we didn't even check the granddad, and we didn't check Daniel Pikus. It's granddad's car, so he doesn't own a car. It's not his car. And then Daniel Pikus is the husband. Doesn't it? A lot of people always, it goes to the husband. Cori Bush, she sent a letter to Parson asking him to grant Williams clemency. You have it in your power to save a life today by granting clemency to a man who has already unjustly served 24 years in prison for a crime he did not commit. And I'm urging you to use it, she writes in a letter. Republican Mike Parson, who's also a former sheriff, the governor of Missouri, fucking Missouri racist bastards, have been in office for 11 executions and has never granted clemency. Never? How you been in office for 11 years? I thought 8 years and never clement? Never? How unmerciful.